So first of all, you have a right to reject within the first 30 days. Now, this Act from 2015 offers car buyers more rights than previous acts, as it includes the sale of new and used cars. Or you find that it wasn't as was advertised, then you can raise this with the seller and ask for your money back. Neither the T-Junction or any representatives are registered with the Financial Conduct Authority, the FCA, or any legal bodies, and therefore cannot give you legal or financial advice. Any information contained in this episode is merely for information and education. The sources of this information can be found in the description of this video. So picture this scenario. You buy a car, and all of a sudden you see a warning light appear on the dashboard, or the car starts to misbehave. What do? What are your rights? Are you protected? And is there any legislation in your favour? Welcome to the T-Junction. I'm Jats, and in today's episode we look at this very thing. So many dealers are giving customers a 6-month in-house warranty these days, but what does that actually mean and why are they doing that? It's a perceived incentive for something that maybe they're indirectly obliged to provide, and that's something that we'll be covering on this episode. Now, I've been contacted by a viewer who purchased a car a few months ago, and she had a drivetrain warning on her car within just a few days of actually purchasing the car. Now, over the last few weeks and months, it's actually turned out to be a mechanical failure in the gearbox. And having helped her, I thought I'd share my thoughts on this with you. So cars are way more reliable than they ever were, but they are also way more complex than they ever were. Cars can be great when they work, but what if something isn't right? What if you get something that looks like a minor dash warning, but turns out to be something more serious, or it's hiding a more serious problem underneath? Well, the Consumer Rights Act 2015 was introduced on the 1st of October 2015, and it covers all goods and services purchased from traders and dealers. Now, this includes cars too. You might want to click on the link on this page here or in the description of this video, which takes you to the official pages from the government on this. And Chapter 2 of the Act is the reference that covers most of what I talk about here. Now, legislation can change, so I always say, research the latest positioning through the relevant government pages or with the citizens or consumer advice teams. You can find a link below to them just here or in the description of this video. Only take both financial and legal advice from people who are qualified to provide that. The information contained in this video is informational and educational, and I hope it's useful, and if anything, acts as a means for you to be able to start your thought process. Now, this Act from 2015 offers car buyers more rights than previous acts, as it includes the sale of new and used cars, as well as services such as car repair and maintenance. It replaces the old Sale of Goods Act, but retains some of the previous Sale of Goods Act's crucial demands, which hinge on 3 key principles. Those principles are that the goods must be of a satisfactory quality. That's number 1. Well, what does that actually mean? It means that the quality should match what you would expect for the make and model. All vehicles should be roadworthy, safe and reliable. The vehicle's condition should match its age, price and its mileage. It shouldn't be damaged or faulty in any way. If you buy a new vehicle, it should function as expected and as per the samples or examples or test cars or demo cars that exist either in the showroom or that they've shown you. If you buy a second-hand vehicle, its condition and performance should be reasonable given its age and mileage. Number 2 is it should be fit for purpose. So what does that mean? Well, it means that the car should be able to fulfill the purpose it's bought for by functioning as it's normally expected to do so. So to give you an example, if you were to buy a van and it says it can carry 3.5 tons, well, it should perform safely and, properly if it's carrying that sort of weight. If, on the other hand, you've bought a car and it's advertised as having a 500-litre boot space, well, it should have a 500-litre boot space. If it doesn't, and it's smaller than that, well, you've got some recourse there. And then number 3, the goods should be as described. So the vehicle should match the description in the advert. The vehicle specification and appearance should be the same as what was mentioned before the purchase, or as per the sample in the showroom. If it's a second-hand car, let's say, for example, then its condition and performance should be as described. If the car or any goods or services that are purchased by you don't meet any of these 3 criteria, then you may have the following options. So first of all, you have a right to reject within the first 30 days. Now, if there's a problem that means your car doesn't meet any of these three criteria, or it develops a serious fault, or you find that it wasn't as was advertised, then you can raise this with the seller and ask for your money back. Now, in this instance, you should be entitled to a full refund within 14 days of the dealer agreeing to the refund. The second one is a right to repair or replace. So if you find a defect after 30 days, but within 6 months, you can request a repair or a replacement. Usually you can't sort of demand which of those you want. It's down to the dealer to decide what's best. But at least you do have the opportunity here to get this issue resolved for once and for all. You are entitled to this right if the fault was there at the time of delivery, unless the seller can prove it wasn't. You can, of course, insist on a specialist diagnosis by a third-party company, which may confirm that the fault was present at the time of the sale, or not, as the case may be. The Consumer Rights Act stipulates that dealers will only get one chance to repair or replace the product, in this case, the car. So dealers can't make multiple attempts to fix a problem unless it's agreed with you. And this is critical, because if they fail to remedy the fault in one attempt or within a reasonable amount of time, you'll be entitled to a refund. Now, it could be full or a partial refund, depending upon your circumstances. Alternatively, you can ask for another attempt at repairing, replacing, or maybe even some financial compensation if, let's just say, you've been off the road for a while and it's cost you. The law says in almost every case there can be no reductions from any refund given in the first 6 months. That sounds interesting, doesn't it? But there is an exception, and that exception is to do with the sale of motor vehicles. Never mind, eh? Where the seller can make a reasonable reduction in the refund or for an amount that the car has been used for. Now, the Consumer Rights Act recommends a reasonable reduction. But what is a reasonable reduction? I mean, I think as a rule of thumb, and this is just a gut feel from me, it depends on the car. It depends on the age of the car, the cost of the car, whether it is a premium model or a family car, etc. So, for example, a reduction of, say, £30 for every 1,000 miles you have travelled could be reasonable for a £7,000 family car. But it could be £500 for every 1,000 miles travelled if it was a nearly new £120,000 luxury saloon. So you do have to work with a dealer to agree what's reasonable. So if you do get a problem with your car, then what should you do? Well, the very first thing you should do is get in touch with the dealer and do that immediately. Be polite, be courteous and professional. Tell the dealer that you are aware of your rights as a consumer. Make sure you do everything in writing and keep a clear record, taking photos and videos of the issues as it occurs, especially if it's an intermittent one, and keep a note of the time and date when the fault occurred for every single occurrence. Anything you agree verbally should be followed up by an email or a text confirming the detail of that discussion. And if the dealer mentions any cost of repairs, make sure you understand the cost and agree only if you're okay with it. Now, if you're not okay with any of this and you need more advice, then get in touch with the Consumer Advice or the Citizens Advice Bureau for more guidance. And they are an incredibly useful source of information, and they will support you through this process. Now, remember, I'm not legally trained, so I can't give you legal advice, but they should be able to give you the correct advice. Now, there are other laws that may also protect you as a car buyer. If you've bought a car on hire purchase, or HP as it's called, or PCP, or a lease, or something like that, you may be protected under Section 75 of the Consumer Credit Act 1974 and the Consumer Rights Act 2015, so both of those in combination, effectively. Remember, in nearly all cases of PCP or HP, the finance company will own the car at least until you have paid 50% or so, and will share the responsibility for it with the dealership. In the case of the viewer's example, she has raised a complaint with the finance company because she has HP on it, and they have intervened and are assisting through their complaints department. If you spend between £100 and £30,000 via credit card, you get extra protection as a consumer through Section 75 of the Consumer Credit Act. And your card provider should share responsibility with the company you paid for the car to. So you may find that you're covered for the full amount of the car, even if you only paid the deposit using your credit card. And that's one of the advantages of using credit cards to make part payments towards cars. So it's always best to check for any caveats with them and by consulting them and the terms of the Act. The consumer and citizens advice teams can also be very useful. So if you speak to the Citizens Advice Bureau, they will also be able to help unpick this for you. Under the Consumer Contracts Regulations of 2013, you can cancel your order within the cooling off period of 14 days after purchasing a vehicle. So even if you've taken delivery, you have 14 days, and most people don't fully understand or what the implications of that are. So it's always worthwhile just bearing that in mind too. Now, under the Consumer Protection from Unfair Trading Regulations 2008, it's illegal for dealers to provide incomplete or false information or engage in unfair business practices. Vehicles bought on credit are covered by the Financial Ombudsman Service, the FOS. The Motoring Ombudsman is also very helpful and can provide support. You'll see a link below or in the description of this video to the Ombudsman. If you're buying a car privately, which includes classified ads and eBay-type auctions, then it's the seller's legal responsibility to ensure that they have the right to sell the car, that's number one, and that the vehicle matches its description and it is roadworthy. If there's anything wrong with the car, if it's for spares or anything like that, then it must state that very clearly in the advert, and you should be told that. There should be no surprises. Now, you can try following the same principles as outlined in this video if you have bought a car that appears to have a fault privately. But if they don't play ball, then you may have to seek legal advice and go through a small claims court, for example. Remember to only ever take legal and financial advice from people or companies that are qualified to provide it. Please let me know in the comments below if any of this has ever happened to you and how it went for you. If you like this video, then please hit the thumbs up. Please subscribe to the channel. I'd be really grateful if you did do that. And thank you very much indeed for watching. I'm Jats. This was a T-Junction Top Tips video. Thank you very much for checking in and watching this episode. I'm checking out, and I'll catch you on the next one.